You would want a judge not to make rulings on a document that they haven't seen. I mean, come on.
Your Honor, I
I
agree.
mean,
I
that comes as a
understand.
surprise to no one.
It does not.
Moving on to document 627, Plaintiffs' motion limine number 2 to pre-admit government reports. I have an ETT opposition there to 808. Real Waters Joinder to ETT opposition, non-substantive 892. Plaintiffs reply, the court's inclination is to grant that because realistically, the government reports that are set forth specifically in the motion would meet the appropriate standards to pre-admit them, taking into account the ET&T opposition, like I said, and the joinder there too. That's just an inclination. Counsel for movement, go ahead, please.
Thank you, Your Honor. I won't belabor the point. I think your inclination is correct. All the government reports are authentic. There's really, or they're not issued from the federal agencies in which they come. They're not hearsay or not inadmissible under the hearsay rule under NRS 51.155 because they set forth the activities of officials or agents, public officials or public agencies. It's an MMWR article published in the Morbidity and Mortality Weekly Report on it pursuant to Code of Federal Regulations. The establishment inspection reports are inspections setting forth the activities and factual findings of the FDA based on inspections, which is also listed under NRS 51.155. And finally, they literally set forth the observations of the FDA at these inspections and as part of their investigation under a duty imposed by law. They cite the federal regulations under which the observations are made, and they're relevant and not unduly prejudicial. There's nothing confusing about these government reports that contain straightforward factual findings and observations pursuant to duty imposed by law. They are relevant. The only argument is that they're somehow not relevant because the investigation took place in early 2021, but
But you haven't disclosed the fact it's 2021, right?
Yes, it says it's in 2021, and regardless, that argument ignores the fact that it's still relevant circumstantial evidence to the conditions that existed prior to the time that they inspected. Now, if they want to, present evidence or argument that there was something materially different than what was observed at the time of the inspection, then that's something completely different than what they're trying to do here, which is to exclude clearly relevant and admissible evidence as based on just a bald assertion that it's somehow irrelevant to Myles Hunwardsen's claim. So for all those reasons, Your Honor, I think the court's inclination is correct, and we'd ask that the motion be granted.
Okay. I'm going to take Terrible Herbst next, and then Real Waters, since you did a non-substantive joiner, and we'll see if you want to be heard afterwards. Okay? Go ahead, counsel.
Morning, Judge Jan Tomasik for Terrible Herbst.
Appreciate it. Thank you. Go ahead, please.
Even if there is some relevance in these governmental reports to Hunwardsen's claims.
So can I stop for a quick second? Are you saying she said they were not, or she didn't have sufficient reason to conclude?
Well, the deposition testimony is in the opposition, Your Honor.
Right. I was reading from it, page 6, actually. That's why I asked the question.
Yes.
No worries. I am reading your opposition, right? Page 6, starting on line 16.
Mm-hmm.
Right. The question was, but the Southern Nevada Health District and CDC did not have sufficient reason to conclude that there were any cases before August 1, 2020. You left that as a cutoff date for the case definition true, right?
That's correct.
So, I'm sorry, I thought you said they affirmatively concluded there was not a link versus the way the question was phrased, right, a sufficient reason to conclude they were. So I was just wondering if there was another quotation that you were referencing.
No, Your Honor, I'm referencing this testimony.
No worries, go ahead, please. Thank you.
And that confusion is exactly why, even if the governmental reports do have relevance to Hunwardsen's claims, they should not be pre-admitted and they should be excluded because they're confusing and prejudicial to the jury as it pertains to the claims made against Terrible Herbst. All of the findings and all of the results of the governmental reports are based upon investigations post-dating August 2020. NRS 51.155 under subsection 3 indicates that these types of governmental reports are admissible unless the sources of information or the method or circumstances of the investigation indicate lack of trustworthiness. Now, right underneath that, we cited to Frias versus Valley, which is different in many regards, but the same kind of concept exists, is that we should not allow the jury to be persuaded by cursory inspections, and the same thing here. There was no investigation of the retail bottled water sold by Terrible Herbst, and so by allowing governmental reports that have no emphasis on that point to be admitted, it's very akin to what happens in Frias versus Valley, where you have a cursory inspection and the citation or finding a fault is based upon something that's after the fact. That's exactly what's happening here as to claims made by Hunwardsen against Terrible Herbst. And with that, I'll submit.
Appreciate it. Good sense. Counsel for Real Water Juice, we heard you had a non-substantive joinder.
Nothing to add, Your Honor.
Okay, appreciate it. Counsel for Plaintiff, if you get last word, go ahead, please.
I think Your Honor identified the problem with the citation to the Dr. Zhang testimony, but for the record, I'll just clarify. What Dr. Zhang testified to was that they did not investigate any claims of liver injury related to real water prior to August 1st, 2020. They set that date as a cutoff prior to the investigation. And so any reports of injuries related to real water prior to that date were automatically excluded and not investigated. And so Dr. Zhang said this when repeatedly asked to try to give an inaccurate response that could be suggested as the Southern Nevada Health District made affirmative findings that there were no cases prior to August 1st, 2020. She said, quote, "If they had an illness outside of the time period of our case definition, which was prior to August 1st, 2020, we wouldn't investigate them. Therefore, we wouldn't know their consumption of real water. So we cannot really say anything about whether they're linked or not." So Dr. Zhang's testimony is clear. Southern Nevada Health District did not investigate any claims prior to August 1st, 2020, and they made no affirmative findings that there were no cases prior to August 1st, 2020. The only reason that this is confusing at all is because Terrible Herbst has cherry-picked quotes out of context and attempts to mischaracterize them. In terms of the Frias citation, Your Honor, this isn't a cursory inspection or the findings of fault in a traffic accident situation. It's investigation conducted by the FDA in response to reports of a very serious outbreak of acute liver failure injuries. I'd remind the court that Myles Hunwardsen had a liver transplant, which is about as bad of an injury as you can get in this case, except for the person who died. So this is this is a serious thing that the FDA investigated. There was an epidemiological investigation. Those reports set forth findings of fact based on inspections and observations. They're not being used to give an opinion as to fault in a traffic accident. And in fact, the defendant manufacturer in this case, it concedes to fault to begin with. So these reports, as your initial inclination reflects, are plainly relevant and admissible in this case, and we ask that you stick to the initial inclination and grant the motion.
I shall stick. Okay, court grants the motion eliminating number 2 to pre-admit government records, which was document 627, opposition by ETT 808, Will Waters Joinders on substantive 892, and the reply 937. The court really finds, I mean, you've stated, set forth that they are not inadmissible as hearsay under government records. NRS 51.155 also set forth how they have been analyzed really from both sides with regards to the scope and breadth of how, I said both sides, all sides, excuse me, is what I meant to say, have utilized as a foundation for various time periods and how they're analyzing each of the parties' claims, defenses, etc. They therefore are relevant, and they're also more probative than prejudicial. And so for all those reasons, the court finds it's appropriate to grant motion eliminating number 2, and will pre-admit the government reports set forth in that motion only. Thank you so very much. Moving on to plaintiff's motion eliminating number 3 to pre-admit the FDA concentrate testing reports, which is document 597. ETT's opposition thereto, 807, 924, plaintiff's reply. The court's inclination there as well is to admit it for all the reasons set forth in the motion and in the reply, fully taking into account that the opposition sets forth what it sets forth, but realistically, particularly with these FDA, it really allows the parties to address what their claims are and what their defenses are, and facilitates the various time periods with regards to when consumption took place. And here, once again, you're focusing on Hunwardsen because I did not see any additional opposition from Real Water on this one, so we're focusing on one individual where part of the argument is time period and actual consumption. That's the court's inclination. Go ahead, counsel.
Your Honor, for the same reasons as the last motion, we have nothing to add.
Okay, thank you so much. Counsel for ETT, Terrible Herbst, go ahead, your opposition.
Jan Tomasik for Terrible Herbst. This court should deny plaintiffs' request to pre-admit the FDA concentrate testing reports. The FDA testing reports are of real water samples. They were all manufactured after Hunwardsen's transplant and long after he quit drinking real water altogether. To the extent that the plaintiffs argued that the concentrate was tested, the report clearly mentions that there's no manufacturing date, and so by allowing pre-admission of these reports, the jury will be confused, and Terrible Herbst will be prejudiced by a pre-admission of said reports because there's no proof that these reports relate to the product sold by Terrible Herbst.
I appreciate it. Thank you so very much. Counsel, you get last word if you want it.
Nothing to add, Your Honor.
Okay. Court is going to grant plaintiff's motion eliminating number 3 to pre-admit the FDA concentrate testing reports for all the reasons set forth in the plaintiffs and adopt the court's inclination, all the reasons set forth therein in the case law, like I said, set forth in the pleadings. It seems to me, what the court's trying to decide is whether we should take an early lunch, because I know you all are trying to get a couple of different things done, and that way my team gets in to the extent you might need to address some other issues. I was thinking, or we could go one more. What's your all's thought?
Your Honor, the next one is pretty much the same. If we could just do the number 4 and then take the early lunch like you're suggesting, Your Honor, that would be great.
I'm sorry, you mean number 5 to pre-admit the Europins?
Yes, Your Honor.
Right, but the court's going to have questions on that one in light of the Whole Foods versus Terrible Herbst issue.
Your Honor, do you have any issue on motion limiting number 4, which is the Loma Linda one, which I think is very similar to this
I'm
one?
not there yet.
Oh, I know, I'm just trying to
No,
sneak
I'm
one in.
I'm trying to do, I told my team what order. You can appreciate with these huge numbers, right? We're trying to keep the order, so that's why we prep, which is obviously get those taken care of. So, okay, we'll do one more. We'll do plaintiff's motion limiting number 5 to pre-admit the Eurofins retail bottle testing, finding hydrazine in all 7 Whole Foods bottles tested. The court, in this regard, is not going to have a specific inclination because the court's going to have a question with regards to now, in light of what has been forecast, as one reason why I was wondering if you want to take a lunch break, as been forecast is what the stipulation between Real Water and plaintiffs is. And since the only party who filed an opposition is Terrible Herbst, how the Whole Foods bottle testing would apply to Terrible Herbst. So the court's going to have a question on that. That's why I don't have an inclination. Like I said, we can do it now, or we can take an early lunch, whichever you all want to do.
We'll go with your court's inclination to take a lunch, Your Honor.
That meets the needs of everybody else? Okay. So, in light of where you all need to do, it's 11:20. Do you want to come back at 12:30, an hour and 10 minutes? Give everyone the time they need to do what they need to do? Or do you need more time?
I would think we need a little more time, Your Honor. We may have to bring this in a written
12:45?
form. That sounds better, Your Honor.
12:45 works for everyone then? Okay, see you then at 12:45. Thank you so very much. So we'll move forward, go on the record then, please. Okay, back on the record, case number 831-543, Hunwardsen versus Committee Myles and PTT EBA Terrible Herbst. Also, same counsel, same parties. We, right before the break, we were about to do document 629 and related opposition 821 and reply 924 was plaintiff's motion eliminating number 5 to pre-admit the Eurofins retail bottle testing, finding hydrazine in all 7 Whole Food bottles tested. The court told the parties before you broke for lunch the court was going to have a question about, since this is not Whole Food, since this is Terrible Herbst. Yes, I am familiar with, particularly in the reply, where the movements set forth that it should be basically the same because of the concentrate argument, but realistically, I need to let counsel for plaintiff, it's your motion. Go ahead, please, succinctly if you want to. Oh, do we have, was Blue Jeans back on? Because there were some people who were watching and observing. Okay, we just have a blank screen. I just want to make sure they were taken care of as well.
Yeah, it's for their documents.
Yeah, no worries. I have a blank screen. I have a blank blue screen. That's why I was asking. Usually I can.
Yeah, they're on.
Okay.
I think that's because I'm on the screen, Your Honor. But Blue Jeans should still be active in the background.
Yeah, that's,
Usually my screen still shows people.
Oh,
That's why I was making sure it was taken care of. But as long as everyone has access to the courtroom, either in person or remotely, then we're good to go. Counsel for plaintiff, feel free to proceed.
Yes, Your Honor, I think I would just start by, saying that I think the authenticity of the Eurofins testing is uncontested. We have the deposition testimony of the 30B6 from Eurofins, Mr. Neslin. He testified that the test about performing the test results as being true and correct of the testing that he did, and that the test report that was disclosed is a business record of Eurofins. So in terms of authenticity and admissibility under the hearsay rule, I think those are pretty easily established. The question of relevance, I also think is very easily established. As Your Honor correctly noted, the evidence and facts, what they clearly show is that Real Water was inadvertently producing hydrazine in the E2 concentrate. The expert testimony from plaintiff's expert, Dr. Najam, who's I think widely regarded as the premier expert on hydrazine formation in water, opined about how the electrolysis process and the titanium tubes with the chemical solution, and when they were making the E2 concentrate, was producing hydrazine in the concentrate. That concentrate was a proprietary product of Real Water, and it was only ever made in the Las Vegas facility by typically Blaine Jones, and if not him, early on, maybe the original inventor, John Marlowe, or His dad may have been privy to it, Brent Jones, the owner. But Blaine Jones primarily made it at all relevant timeframes in Las Vegas in a locked room behind closed doors, so no one would know the secret process. And then that same concentrate was stored, the concentrate with the hydrazine in it, and it was used to make all the finished product of real water, whether it was 5-gallon made in Las Vegas, in the Desert Inn facility, in the Henderson facility, whether it was retail water made at the Desert Inn facility, whether it was retail water made by a co-packer in another state, they would use the same proprietary E2 concentrate made by Blaine Jones in Las Vegas. So the FDA found the hydrazine in every sample of the E2 concentrate for which it was tested. They used the concentrate to make all of real water. So the evidence is that the hydrazine was being added to all real water when they added the E2 concentrate to make the finished product. And the Eurofins retail bottle testing is highly compelling corroborative evidence of that fact. If you're making the hydrazine in the E2 concentrate and you're using the E2 concentrate to make the finished product, and you're presuming based on that the hydrazine is in the finished product because the E2 concentrate is being added to it, then test results of any product that the E2 concentrate is used to make is highly relevant and supportive of the facts and evidence of what happened in this case. The Eurofins testing is I think, even more relevant because it debunks a couple of the issues raised by Terrible Herbst in this case, which is in line with what other retailers have raised in other cases, namely that, oh, this was a problem. We don't know what the problem is, but whatever it is, it was only the 5-gallon in Henderson problem. The retail bottles that were tested by Eurofins, they were manufactured at the Mesa facility. So the real water, the E2 concentrate made in the Desert Inn facility was shipped to Mesa when they split the operation to Henderson and Mesa. And they used that E2 concentrate that was shipped from Las Vegas to make the retail bottles. Those retail bottles were real water bottles. You know, the different distributors would come and pick them up and take them to different retailers. The particular bottles that were tested were picked up by United Natural Foods and held in the United Natural Foods warehouse for a couple of years before they were tested. But this was all real water product. There's not, as Mr. Parker, I think, very comprehensively explained earlier, there's not, this is a Terrible Herbst product and this is a Whole Foods product. It's all real water product made at real water with the real water concentrate, which had the hydrazine in it. And so the Eurofins testing of the retail bottles shows, one, it was in the retail bottles that was manufactured by real water and distributed through a variety of retail sellers. And two, it wasn't related to the Henderson facility because the evidence is that the E2 concentrate was made at the Desert Inn facility before the move to Henderson, and the retail bottles that were tested were made at the Mesa facility. So for all those reasons, the Eurofins bottles the Eurofins testing is authentic, it's not hearsay, and it's highly relevant on multiple issues. And with that explanation, Your Honor, I know you mentioned you potentially had some questions that I'd be happy to answer.
No, my only question is, where's the STIP? That you all promised me right? Lunchtime. And that you wanted the early, right? So you had the early lunch and the extra time. I have no STIP submitted to the app as of 30 seconds ago.
Yes, Your Honor. We finalized the STIP over lunch. We have a printer coming down at this moment. We're going to make copies so we can provide them to Terrible Herbst Counsel before we submit it to Your Honor. But I would add, with respect to this issue, if Your Honor would like to wait to see the STIP, I understand. But really, I don't,
Counsel, that was my simple question.
Yes, sir.
Close the step. Thank you so very much. Appreciate it. Okay. Opposition, counsel. Document 809, ETT's opposition. Go ahead, please. Oh, yeah, I'm sorry, 821. I meant to say. My apologies. Go ahead.
Good afternoon, Your Honor. Jan Tomasik for Defendant Terrible Herbst. Your Honor, if the Eurofins testing is admitted, Terrible Herbst will face insurmountable prejudice. There's more differences in the product that was tested by Eurofins than there are similarities. In this case, where everything hinges on circumstantial evidence as to the retail bottle sold by Terrible Herbst, it's not that Terrible Herbst is asking based on no evidence that, Your Honor, exclude this evidence. We have presented, NEV-BEV employees and their NRCP 30v6 testimony, which shows that NEV-BEV and its customers were consuming the same retail product that Hunwardsen was, and it was contemporaneous consumption. Here we have Eurofins testing that relates to retail products, but the retail products were manufactured long after Hunwardsen quit drinking real water. The manufacture dates, the earliest one is September of 2020, and Hunwardsen quit drinking real water in December of 2019. Furthermore, the product was, product that was supposed to be sold by Whole Foods, and it was distributed by UNFW. So when you look at the product that plaintiffs want to pre-admit, it completely lacks relevance, and it's unduly prejudicial to admit these testing results when the only party that they could be held against is UNFW, who settled out, and the testing lacks relevance to the product sold by Terrible Herbst. And once again, that's especially true when you look at the totality of the evidence and the circumstantial evidence and the fact that millions of consumers were consuming the retail bottles that were sold by Terrible Herbst. Okay, and you have to look at that contemporaneous time period rather than Eurofins testing that relates to product not only manufactured at a different date, it's manufactured in a different bottling plant. Mr. Pepperman just said that it was bottled at Mesa, Arizona, whereas any product that Terrible Herbst would have sold to Mr. Hunwardsen would have been manufactured at the Desert Inn location. Furthermore, there also exists the potential that the concentrate that plaintiffs allude to is not the same concentrate that was utilized to make the product that Mr. Hunwardsen consumed, as well as the product that NEV-PEV employees and millions of consumers consume. With that, I'll submit.
Appreciate it. Thank you. Counsel, you get a brief last word if you want it on behalf of plaintiff.
Your Honor, the hydrazine problem was going on for years before it was discovered. It was a super bad outbreak that prompted a report by chance that led to an investigation. So the testing and the investigation that was done when they learned about the problem does not mean that the problem didn't exist before. In fact, it's evidence that is relevant to whether it existed before, because it goes to whether the conditions at the time that they found the hydrazine were the same going back at other times. They say there was millions of bottles sold, but we have plenty of complaints going back years related to the retail bottles of evidence that hydrazine was in this water. In terms of
From these plaintiffs in this case, is that your statement, or just in general?
Well, plaintiffs in this case go back before.
Do the complaints go back for the plaintiffs in this case?
No, Your Honor. There are
Thank you.
customer complaints from records we've collected from Real Water that show evidence of hydrazine. And then, of course, there are numerous claims that have made once the connection was drawn that go back years in time.
But I'm trying to go to these plaintiffs. Are the claims from, you're saying there's claims from these plaintiffs that predate?
2020?
Yes.
Yes, Your Honor. Myles Hunwardsen suffered his injury in September 2019.
No, my question actually was a little Right, you were saying these complaints go for years and years and the bottling and the aspects are the same. But for these parties, are those ones you're referencing go back for years and years or not? Or is that just a general statement on complaints regarding real water?
There are complaints from Terrible Herbst customers that go back years and years, but overall, I'm just generally referring to related to real water.
Okay.
You know, and that's the problem, is that Real Water was making this water, and the way they did it produced hydrazine. They did it the same way all the time. There's evidence of a hydrazine in the water going back several years, and so evidence related to testing of bottles in 2021 that's consistent with all that evidence is absolutely relevant. I also note that Dr. Goldsmith, who was the epidemiology expert retained by Real Water, he looked at the urethane testing, and he called it, from an epidemiological evidence standpoint, the smoking gun that showed this was far more, this was a company-wide problem and not limited to any one type of product line, such as the 5-gallon. Last comment, there was a suggestion that I admitted that, you know, the bottles were made at a different facility, and I at least a misintent from what I had said. The urethane testing included bottles that were made at the Mesa plant. So that is true, but it also, the urethane testing also included bottles from September 2020, which predate the commencement of the Mesa facility. So those bottles that were made in September 2020 were made at the Desert Inn facility. So the urethane testing encompasses retail bottles that include both retail bottles made at the Desert Inn facility and retail bottles made at the Mesa facility. And that just reinforces the point that it doesn't matter where these bottles were made or where they were sold or which store sold them or whether they were home delivery. What matters is they were all made from the same concentrate, which had the hydrazine in it, and the hydrazine was put in the retail water and the 5-gallon water when the E2 concentrate was added to make the finished product. Thank you.
Okay. The court is going to deny plaintiff's motion eliminating number 5 to pre-admit the Eurofins retail bottle testing, finding hydrazine in all 7 Whole Foods bottles. The court takes no position on whether it can be admitted during the course of trial, but the plaintiffs have not met their burden to pre-admit it in light of who are the actual parties in this case, the claims and defenses in this particular case before this particular court, and so therefore the court has to deny the pre-admission of the Eurofin retail bottle testing. Moving on to document 630, motion eliminating number 4 to pre-admit the Loma Linda article from the American Journal of Gastroenterology. Document 809 is ETT's opposition thereto. Document 925 is plaintiff's reply. The court's inclination on this one as well is to deny it without prejudice for pre-admission only. For a similar concept, really, the court's analysis with the Eurofins is you've got 4 individuals in Loma Linda that have a different time frame, don't have it tied into for what you all have presented to this court in your pleadings, right? I have to look at the status of with regards where the pleadings are before this court, right? Not some additional oral argument that might come up in front of me, but that's just a court's inclination. Counsel for movement, go ahead, please.
Thank you, Your Honor. So, Your Honor, I understand the court's inclination, and it seems to be based upon the chronology or the timing of the patients, the 4 patients discussed in the Loma Linda report versus the plaintiffs that are part of this case. Am I correct or incorrect on that?
Remember, the only opposition I have there too is for Hunwardsen. So remember, my inclination is only as to Hunwardsen because that's the only opposition. I'm not taking a position on with regards to the other plaintiffs because the other plaintiffs there's not an opposition, so you got an DCR 2.20 issue there. So
then let's consider this because this may shorten some of the discussion.
Sure.
If we were to pre-admit this document and say as a part of our opening that this document as of this time only relates to the remaining plaintiffs, then that would not run foul of the court's inclination, correct?
Well, you have to realize, I don't have an Hunwardsen, right, from a standing standpoint, has only raised the issue in regards to the only, right, they even say in their opposition, the only plaintiff that relates to their defenses in this case, right, in which it's purportedly bought at their particular location was Hunwardsen. That's what it says in the opposition. I do not have any opposition from Real Water, so realistically, I was inclined, that's where my inclination was going straight with Hunwardsen. To your specific request, I'd have to give, well, I haven't heard their opposition yet, so I have to hear what their position is before I make a determination, because they may be raising something that I don't yet know about.
You know something, Your Honor? I'll reserve all of my time for rebuttal because it's looking at their opposition, they've raised 3 points. One is the investigation did not include injuries preceding August 2020. Number 2 is the 4 patients did not indicate jugs versus retail bottles. And then number 3, were there any manufacturing differences between Henderson versus Desert Inn and Mesa? So given because that's your argument is actually more refined.
I don't have an
than theirs.
argument. I just have an
No,
inclination. I'm only a judge. I only make inclinations and rulings.
Not only, I would never put only in front of judge. But Your Honor, what I'll do is I'll allow the opposition and then I'll save my time, or the bulk of my time, for the rebuttal.
Okay, counsel for ETT. Who's taking this one? Go ahead, please.
Jan Tomasik for Terrible Herbst. Your Honor, I think it's very tough to proceed on some of these issues in light of the stipulation that's pending, and in light of the fact that if we allow plaintiffs to make certain arguments, we also have to consider that Miriam Brody consumed retail water with Costco. She settled out, and that there's prejudice when we admit information and pre-admit certain articles to go in front of the jury, which may weigh on retail bottles consumed by a different plaintiff other than Hunwardsen and purchased at a different time from a different retailer. So it's tough to piece out how plaintiffs may carve out an exception to where in their opening statement it may not have the prejudice to Terrible Herbst. In light of that, the article itself states that the changes in the manufacturing process in 2020 were the real crux of the problems associated with these individuals that were discussed in the article. And so, that definitely postdates Hunwardsen. He, again, quit drinking all real water products in 2019. And here we have an article that speaks to changes in the manufacturing process in 2020. Now, putting all other issues aside, in plaintiff's rebuttal, on page 9, in footnote number 3, they state, further, at the time of the article, the authors did not have the benefit of the FDA concentrate testing or the Eurofins testing to know that the real water product contained hydrazine. So it also seems like this article lacks a full scope of the investigation and the foundation, and therefore it may be misleading to pre-admit in front of the jury.
I appreciate it. Thank you so very much. Counsel, you wanted a final word? Go ahead, please.
Thank you, Your Honor. Your Honor, looking at their opposition and comparing that to the Loma Linda actual article, I don't see where they've raised the precise issue that the court said was leading it to perhaps denying this one without prejudice. Their suggestion about manufacturing, Your Honor, this is a 3-page article taken out of the American Journal of Gastroenterology. I don't see where that's raised necessarily, and I don't see where they distinguish between bottles and jugs. What this is an account in one of the most recognized American journals in medicine. I mean, the American Journal of Gastroenterology is recognized as an authoritative work by the defense experts, certainly by our experts. There's no suggestion that this is a group of doctors that has any axe to grind or dog in this fight. This is purely a peer-reviewed article that was based upon biopsies taken of liver samples of these 4 patients. And so in terms of relevance, there's no argument that can be made there. In terms of probative value, there's no argument that can be made there. Given the Beatty versus Thomas case, Your Honor, and the Guinness versus Mapes case, pre- and post-injury issues are relevant, and the Supreme Court says are admissible. So now we get down to the one issue which I believe Your Honor's question, it seems more pointed than the opposition, quite frankly. We took the deposition of one of the authors of the Loma Linda report, Your Honor. Mr. Kemp took his deposition. If you look at the report, Exhibit 1 to our motion, Your Honor, you see Dr. Amar's name as a second name as the author of this report. He was deposed. His conclusion, supported by the biopsies, is that hydrazine in this alkaline water caused the acute liver failure. To suggest that this document shouldn't come in, especially given the poor opposition that's been put in front of you, Your Honor, I think it's inappropriate. In terms of timing, and this is something that you asked, I don't know if Mr. Pepperman completely answered your question, Your Honor. We have plaintiffs in 18, 19, 20, different years. And the information that he was trying, Mr. Pepperman was discussing in the prior motion, limine number 5, and what is important here is that the water manufacturing process never changed. The E2 concentrate never changed. So the plaintiffs that we have in this case got the same water as the patients in the Loma Linda report and the customer complaints that were from 2013, I think we have all the way through 2020, as well as, if you want to refer to those, similar in Gallagher. And in fact, Myles Hunwardsen, he is within 20 days of 2 of the other plaintiffs. Keith Haley was within a few days of being in a hospital as Myles Hunwardsen, drinking the same water, Your Honor. There's no reason this document shouldn't come in, given what the Nevada Supreme Court has said about articles of this type, about pre- and post-injuries being relevant, and given the authoritative nature, peer-reviewed, on top of this document being peer-reviewed, Your Honor. When you look at NRS 48.025, this is the exact type of learned treatise or authoritative journal items that should be admitted, Your Honor.
Appreciate it. I'm going to answer your question in my ruling. Plaintiff's motion eliminating number 4 to pre-admit Loma Linda article from the American Journal of Gastroenterology is granted in part and denied in part. It is granted with regards to everybody other than Hunwardsen. There is no opposition, EDCR 2.20, so it is granted. With regards to Hunwardsen, it is denied without prejudice. Remember, this is only for pre-admission, and realistically, it does set forth in their opposition at this juncture for pre-admission is it sets forth what their contention from an argument is the limitations of the article, and from a time period standpoint, that's actually on page 6 of their opposition. I went back and checked when you were mentioning that. So at this juncture, the court can't find that plaintiff has met its burden with regards to the relevancy component for pre-admission only as to Hunwardsen, and so that's the court's ruling granting in part and denying in part. Moving on to document 598, plaintiff's motion eliminating number 8 to pre-admit the Goldsmith testimony. The court's inclined to grant that. The court did fully read the opposition. Once again, it's only ETT opposition, 836, and then plaintiff's reply was 932, and the underlying initial motion was 598. There's the court's inclination. Who's handling this one on behalf of plaintiff?
Court's inclined to grant it. I will reserve all my time for both.
Okay, go ahead. Counsel ETT, you've got the opposition on this one. Go ahead, please.
Thank you, Your Honor. Trevor Everett with Terrible Herbst. With respect to pre-admitting Dr. Goldsmith's deposition, first point that I'd like to address is that it is not relevant, specifically stating that Dr. Goldsmith's opinion, turn to our opposition on page 4, His opinion states that, in my opinion, it is more likely that hydrazine contamination of the real water concentrate explains the ALF outbreak. I arrived at these conclusions using standard epidemiological methods, and I hold these opinions based on a reasonable degree of epidemiology certainty. His testimony is specific to the ALF outbreak, which is in late 2020, after Mr. Hunwardsen's injury, which we've already discussed, that he stopped consuming real water in December of 2019. His testimony, Dr. Goldsmith, specifically relates to the ALF outbreak of 2020. Is the only reasonable potential for the specific outbreak. He says nothing else is indicating otherwise, specific to the outbreak, not specific to Mr. Hunwardsen's injury. In fact, their entire deposition, they never addressed Mr. Hunwardsen's case. More importantly, however, Your Honor,
Isn't that because it was in the Gallagher case and Hunwardsen wasn't a
Correct.
part of the Gallagher case?
Correct.
I mean, okay,
but
go ahead.
if you could, yeah, so that's where I was leading to my next point. In this case, your case, the case in front of you, Your Honor, plaintiffs disclosed Dr. Goldsmith pursuant to NRCP 16.1A2 as an expert witness. Real Water did not disclose Dr. Goldsmith in this case whatsoever. Plaintiffs now attempt to use Dr. Goldsmith's opinion in their favor when he was not disclosed by Real Water in this case.
Why couldn't plaintiffs disclose them, right?
Plaintiffs did disclose him
That's what I'm
as,
saying.
as an
But
expert.
I'm trying to have a better understanding of what your contention is,
Perfect.
of why there's something that would not be appropriate or accurate for plaintiff to disclose.
The plaintiffs, they list him specifically as an expert, as their expert in this case.
Timely disclosed, right?
They did not retain him, they did not provide a compensation structure, and they did not provide a report supporting their contention. They're trying to use Real Water's opinion in Gallagher, what he stated in Gallagher, and then use it here to support their arguments as plaintiff's expert, not as Real Water's expert. According to NRCP 16.1A2, he did not prepare a report subject to an agreement made with plaintiffs. They did not provide any sort of retainer or contract agreement. They did not provide the contract or the compensation structure that Dr. Goldsmith agreed to specific with plaintiffs. What we are relying on is a contract that Dr. Goldsmith entered into with Real Water in the Gallagher matter as a defense expert. Here he's been disclosed as plaintiff's expert with no subsequent report or information regarding the compensation to be paid. Also, would you like me to continue?
Yeah, of course. I'm just making sure we got. Do you want us to pause for a quick second while we do a change? No, okay. Sorry, we just have a different court recorder
No, no.
helping us out, so feel free to continue.
Yeah,
Please.
so in light of that, Terrible Herbst was never able to cross-examine or address any of these positions that they are using Dr. Goldsmith's opinion for.
But didn't you designate a rebuttal of a Dean Ellis?
We have Dr., which we discussed earlier with the dirty dab theory.
Right, but only that was subject to the motion to eliminate, not the total exclusion, because remember I even clarified
Correct.
that point. But go ahead.
Correct.
So,
In light of that, however, they did not produce a report from plaintiffs under a contract that Dr. Goldsmith entered into with them to rebut. He provided his initial report, and then he provided additional information as a rebuttal in respect to the dirty dab theory. His rebuttal is specific to the dirty dab theory. Dr. Cheesen's, Terrible Herbst's expert. Second, under NRS 510551D, Dr. Goldsmith is considered an unavailable witness. Under that section, Your Honor, if you don't mind, a declarant is unavailable as a witness if the declarant is absent from the hearing and beyond the jurisdiction of the court to compel appearance, and the proponent of the declarant's statement has exercised reasonable diligence but has been unable to procure the declarant's attendance or to take the declarant's deposition. It is plaintiff's burden here to satisfy that he is unavailable. Plaintiffs, all that we have on the record states that he lives in Oregon. There's no other additional information regarding his unavailability. They definitely have not complied with the standard as set forth in NRS 51055. They have not exercised all reasonable diligence to indicate that he is unavailable. In fact, in the very contract that he entered into with Real Water, he said that he's willing to appear at trial. Contract he entered into with Real Water, but that evidence suggests that he is not unavailable, but they haven't gone through the process of reasonably exercising all diligence to determine that he is unavailable. And with that, I conclude my comments.
Okay, thank you. By the way, is somebody expecting someone? There's someone keeps on going in and out the doors.
Your Honor, we should have had a printer delivered. That's probably what it is.
I don't know. There's some woman who keeps coming in and out of the doors. I don't know. Marshall, do you want to see if it's? Go ahead, counsel.
Your Honor, first, remember the Real Water is not conceding causation on Mrs. Brody. Mrs. Brody drank retail bottles in 2018. So that issue is still being contested by Real Water. So they are saying that the Real Water and the retail bottles did not cause Ms. Brody's injury. But Dr. Goldsmith, the epidemiologist they hired, testified that he thinks that this is a company-wide problem. And what he means by that is not specific to any particular plant.
And if I should put one quick second, I don't have an opposition from Real Water on this. Real Water, are you contending that there's an opposition?
We have not opposed this motion, Your Honor. Joul
They
Odou for
haven't
Real Water.
opposed this motion. I'm just trying to explain the relevance.
Okay, no
So-
worries. I just
so-
was making sure.
Right. So we have Dr. Goldsmith, and what he testified to is that first of all, the hydrazine is in the concentrate. There's no dispute that that was found in the concentrate because that's what the FDA found. Second of all, there's really no dispute that the concentrate wasn't made exactly the same way year in and year out by the exact same plaintiff. We heard counsel stand up and say it was made by different employees. It wasn't. It was made by Blaine Jones during this time period, and that is clear as a bell of testimony. It was made in the exact same process, in the exact same concentrate room that they wouldn't even let other people into other than Blaine Jones. So where they think that there were other employees making different batches of concentrate, in 2019, where the evidence is of that, I haven't seen it. And, they say it exists, but they don't say one single witness. They don't say one single fact. So in any event, he takes the fact that there's concentrate that has hydrazine in it. That's undisputed. The FDA found it in 3 different samples, not just one, 3 different samples. They only tested 3 different samples. And then he finds hydrazine in the retail bottles from the UNF testing. And as Mr. Pepperman said, those bottles were made both at the Desert Inn location and the Mesa location. Henderson didn't make retail bottles. So the fact that you have hydrazine in the concentrate, the exact same concentrate is used for both the retail bottles and for the 5-gallon jugs. There's not a separate batch of concentrate made and, this goes for 5-gallon jugs and then another batch made for retail bottles. It is the exact same batch of concentrate. And they didn't do this on a daily basis. They only did it every couple months. They made batches of concentrate and they stored it. So Dr. Goldsmith reasons that since the hydrazine is in the concentrate, no problem. So, Your Honor, I couldn't call the guy up. I can't offer him a plane ticket. I can't offer him money. He's the expert of another side. And if they wanted to depose him in this case, they had the right to go to the special master and ask for it. The special master ruled that if it's a generic expert, and this is a generic causation expert, this isn't a case-specific expert. If it's a generic expert, that can be used in this case, the next case, the next case, without having to avail himself of another deposition. But they had the right, if they had some specific question they wanted to ask him, they could have filed a motion with the special master and sought leave to redepose Dr. Goldsmith. They didn't do it. So he lives in Oregon. There's no way I can get him here. I can't even contact him. Real Water doesn't oppose the pre-admission. And I think there's compelling reasons to admit this deposition, especially, and you're going to see this theme come up. You've already heard it. They're making up this claim that there's never been any problem at any time with the retail bottles. So they go so far as to say, 10 million retail bottles were sold. Not one single customer complained. That's totally false, Your Honor. We have evidence 3 Terrible Herbst customers complained. 2 said it was gasoline-like substance in there. We have Ms. Kessler. We have Mr. Fisher. Both drank retail bottles, complained, went to the hospital. We have another witness who even had liver enzyme tests done that were elevated. There are literally dozens of complaints pertaining to the retail bottles prior to this outbreak being discovered. No one linked it up. No one suspected that water of all things could cause acute liver failure. So true, there are no outbreak investigations prior to 2020, but that's because there was no linkage. And the story of the linkage, the 5 babies that went up to Salt Lake and the doctor up there called the health district and said, hey, what's going on? I mean, the community should be grateful to that doctor because that was an astounding discovery he made and potentially saved a lot of lives. But the fact that there are no outbreak investigations before this, totally unwarranted. But that emphasizes why it's so important to have Dr. Goldsmith's testimony, because he explains the general causation, i.e. that the hydrazine in the concentrate was the cause of the acute liver failure outbreak. He says it's a company-wide problem, which explicitly refutes their attempt to point the finger at Henderson. As you'll see in following motions, they're trying everything they can to say Henderson. And the reason Terrible Herbst is doing that, of course, is that Henderson didn't make the retail bottles. So if it's just a Henderson problem, then the retail bottles aren't implicated. But that's why Dr. Goldsmith's testimony is so important, because he says the smoking gun is the testing on the retail bottles. And so for those reasons, Your Honor, we just ask that the court follows pre-inclination to grant the motion. If you have any questions, I'd be happy to answer.
I do. Okay. Because in reading particularly your reply, right, where it says what you just said in oral argument, that to pre-admission plaintiff will refer to Goldsmith opinion during opening. So when I read that and listening to you, I was not hearing that you're planning on playing portions of the deposition.
We are not.
Okay. So that means I now have to ask my next question, because you also said you're not asking the court to rule right now on portions of the testimony. So
Yeah, Your Honor, I've got to take my chance on that like any other case. I'm just trying to get past the unavailability and he's not plaintiff's expert, they don't have a contract with him. I'm trying to get past those particular arguments.
Okay. And that's where I needed this point of clarification, because an opening statement, and you can refer to evidence, is going to say all sorts of things, doesn't matter the source of said evidence, as long as it's a good faith effort and the...
Right, I have to have a good faith belief it's admissible, and I can refer to it. And if I'm wrong and the court disagrees with me, they can try to crucify me in front of the jury with it. That's the way it works.
But part of this motion, more so in its titling than necessarily its substance, does say the word testimony, which was part of the opposition,
Right.
which appears to indicate that you're seeking something broader than a reference to what the evidence is going to introduce. So I need some clarity there to address the opposition argument on what's actually going to happen with Goldsmith, because
what's going to happen is, especially we're getting lazy or we're time pressed, I guess is a better way of saying it. We'll probably use the exact same slide we used before, which Goldsmith said. He's their epidemiologist. He said that just what I've told you, the company-wide problem.
In opening.
In opening.
So then walk through, remember, I wasn't in Gallagher, intentionally can't know about St. Gallagher because I've got Hunwardsen.
Goldsmith's going to be a page line, so we're going to do the page lines on him in compliance with the deadline for the page lines. So we're going to submit the page lines to the court. Presumably, they're going to object to some of the page lines and do counter designations. The court will rule. I don't know if it'll be before the trial starts or if it'll definitely be before the Goldsmith deposition is played. The court will give us the ruling on the page lines and we'll go from there.
That raises a different timing scheduling thing that I'm not going to address right this second, but stay tuned. Put that in your list of things we need to address. So, what is page lines? I don't see. See, the challenge I have here is I don't see an objection. I mean, I'm going to walk this through and I might give Terrible Herbst another moment, but when I was reading this, and I'm coming to the same conclusion now, realistically, is why my inclination was what it was, is a reference to any testimony, doesn't matter the source, can come in opening statements as long as there's a good faith belief, and here, that's fine. I mean, if it's doing specific excerpts, might be a little bit different, but if it's a general statement of it's going to show that witness X says blank, it's a disclosed witness, correct?
Right, he's a disclosed witness. Sure.
Disclosed witness. So then the issue becomes, can you utilize a expert designated? Is Real Water going to use Dr. Goldsmith in this case? I need to ask that quick caveat question. If you want to answer, you don't have to. You actually don't have to answer my question.
Thank you, Your Honor. We did not intend to call Dr. Goldsmith. We didn't list him as a witness.
Okay, so I would just, that was my understanding, but just for point of clarification, so he's not coming in elsewhere, so it's not coming in like for cross
Right.
or some other purpose. It's disclosed, and so the question becomes whether or not you can use witness testimony from another case, but realistically, you all have a special, I mean, remember, here's where I have to go to. These cases are coordinated through discovery. There was an agreed upon special master for the coordination of discovery, which took care of this issue. There was no specific objection set forth to this court for any rulings by Special Master Hale in Hunwardsen. So I have to take what was done by the special master was agreed upon, because you all have a process. And I didn't have to deal with the aspect of whether that would come before me or come before the coordinating judge, because it didn't happen, or at least nobody told me it happened, right? There's nothing on Hunwardsen that you all went to Judge Alphon, correct?
No, you're
Okay.
not with regards to Special Master Hale's rulings.
I'm just saying, yeah, I mean, dates and timings and different things like that, but, so I have no objections on that, so that means it comes in under the special master order issued by Department 27 for your coordination, because if any disclosure issues would have had to happen for purposes in front of Special Master Hale and potentially whoever it would have gone up to at that juncture, and since it didn't, I really view that as waived, and so I have to, for the narrow scope of this motion, I'm going with my inclination after giving you all a chance, and you could hear me walking through my analysis out loud because I wanted to clarify a couple of points, so it's granted.
Thank you, Your Honor.
For all the reasons stated. Okay. Moving on. Document 656, Plaintiffs' motion eliminating number 24 to preclude Revchuk from offering opinion that purported lack of ozonation at Henderson plant would degrade hydrazine in water based on his admission that he cannot know the amount or degree of hydrazation. This one, I have an opposition by ETT, document 865, and the reply is document 929. The question, I'm going to let you do your argument. My question is walking back to your Henderson versus DI, I'm going to ask.
I have a button on this one. So
Go ahead.
what they're trying to do is they're trying to suggest to the jury that there's some unique problem at Henderson, i.e. a lack of ozonization, and that explains the difference between the jugs and the retail bottles. Okay, but the problem is they don't have any linkage here. So remember, ozonization is not intended to reduce the content of hydrazine in water. That is not the purpose of having ozonation in water plants. Ozonization is intended to attack two specific kinds of bacteria who named I knew 2 months ago and I can't remember now. But in any event, ozonation that's what they do ozonization for. So what Dr. Revchuk has done is he has gone to the plant a year after, and I'm not faulting him not for being there on day one, but he went to the plant a year later, took a picture, and he says, oh, the ozonation machine's not hooked up. Okay, great. And he says, as a result of that, there may have been an impact on the hydrazine in the water because there's a paper that says that ozonization can affect hydrazine content. All right, the paper he's referring to is Dr. Galata's paper. What Dr. Galata did is, to kind of summarize it really, he basically took a huge ozonization machine and he zapped water with hydrazine in it at different levels that he programmed. And he zapped it for 3 or 4 days and he reduced the content of hydrazine in it. He did do that. So he did prove that ozonization, in theory, under certain circumstances, can reduce hydrazine content. I'll admit that. But what they want to do is they just want to throw this lack of ozonization out there, and they want the jury to speculate that it must have had a significant reduction of the hydrazine in the real water at Henderson, and that, that the lack of ozonization did not reduce the water at Henderson. So they're saying that the machine was working great at DI, and that's why the retail bottles are fine because it's taken with the hydrazine, but it's not working in Henderson, and so that explains why there's problems with these jugs. So that's how they're trying to sneak this ozonization in there. The problem, and the central thing we focus on in the motion, is there's no linkage. In other words, there's no testimony from Dr. Revchek or anyone else that, hey, if the ozonization machine had been working right, it would have reduced it by this amount, that amount, the other amount. I gave him a range from 1% to 50%. He couldn't even say that. All he could say is, well, in theory, it would have reduced it. I don't know how much. So what they're doing is they're throwing a potential explanation out there with no linkage. And that's, I think, the key problem with his testimony. And again, he's got other testimony. He's got lots of other testimony that we're not trying to attack in this motion. We'll take care of that during cross-examination. But this particular theory, this ozonization theory, had an impact on the hydrazine. You've got to say how much of an impact. You can't just throw out a potential cause, an alternative explanation of the outbreak, and not link it up with any kind of, and if he even had a range, I think, they'd have an argument. But he can't give 0 to 50. And, when in his deposition, I had all the specs for all the ozone machines that were used, and I popped them up, and he hadn't looked at them. He didn't know how many, how much water would go through, how much ozonization, what the flow rate was. They call it flow rate in these things. He couldn't distinguish the machines they had there from the ones in Desert Inn. So this is just an attempt to show the jury a picture of a pipe that's not hooked up and go, aha, this is why it was a problem in Henderson and nowhere else. And Your Honor, that I just think is not appropriate under, again, we're talking about Morsicato, and it's actually Morsicato. I just mispronounced his name. He was a real nice guy. His name was Andy Morsicato. But under Morsicato and Williams, you've got to have some linkage, Your Honor. And there's no linkage here.
Appreciate it. Counsel for Terrible Herbst, ETT, who's taken this one? Go ahead, please.
Good afternoon, Your Honor. Trevor Everett on behalf of Terrible Herbst. First, I'd just like to identify the plaintiffs keep indicating that all concentrate was contaminated with real water. They're not something they'll stipulate to. We still haven't seen it, but their own expert, it's important to note, their plaintiff's own expert states not every concentrate was made the same, and that's been shown. I think that some concentrates were perfectly safe. There was nothing wrong with it. And I think other concentrates were made erroneously or made wrong so that they were toxic and generated hydrazine. Because obviously, if every bottle of real water or every jug of real water was toxic with hydrazine, we would have thousands of cases of liver toxicity, right? Not all concentrate was the same. In fact, Casey Aiken is a real water employee. There's testimony deposition saying that he's probably the one responsible for the bad batch that caused the outbreak, indicating that something in the process was done differently. So this misnomer that all of it was created equally is incorrect. That's from their own expert. With respect to Dr. Rebchuk's testimony, it is important to note that he is specifically opining in regard to the machinery used. This is his expertise area. He's qualified and competent to speak to these matters. He's talking about, after visiting the scene, that the ozone machine was not set up properly, that it looked like it could have added or contributed to the problems. He doesn't specifically address that, as plaintiff's counsel identifies, because he doesn't know, but he does know in his expert capacity what the purpose of an ozone machine is.
Can I stop you there for a quick second? Because you're being consistent with your opposition. So how is it truly opposing what they're seeking in their motion? Right? Because he can't opine, right, that it did or did not do anything, right? He just wants to explain what the purpose of the machine is, or the
Correct.
4 machines that he thought were not hooked up, right? So how does that really oppose their motion? Honestly, when I was reading your opposition, I was trying to see where it seems a little bit of a disconnect of what he actually is opining to that they're seeking to preclude versus what you're saying he really is saying.
So my understanding is that they are wanting to opine causation testimony. Alternatively, we would argue, okay, but his opinion regarding the machinery, the process, what they're used for, how they are not used, what they are supposed to be, and the intended purposes, because he is an expert on that subject matter, that should be allowed. He should be able to present the jury with evidence that, hey, this ozone machine is used, and it was used in the Desert Inn facility, and he said it was appropriately set up in that facility, but when he observed the site at Henderson, it wasn't set up in the same manner, and it wasn't set up appropriately, and the deposition record says that it was haphazardly set up and quickly set up at Henderson, and not consistent with how it was set up at Desert Inn. So,
About the next step. My question goes to that next step.
correct.
Assuming he wants to say all of that,
Okay.
how does that tie to a claim or defense in this? Because it doesn't appear that he was actually going the one step further to say, and as a result, I'm saying that there is a difference in what actually occurred as far as the hydrazine in Henderson versus Desert Inn. Are you saying he does say that?
So he's saying that if an ozone machine is not used or improperly set up, the likelihood of water being contaminated rises. He's not saying that that specific thing happened here, that hydrazine was left in the bottles, and so that should be left to medical experts to determine. But the jury should at least know that these machines were not set up properly, that the ozone machine wasn't even plugged in, and because an ozone machine is used to filter water, the jury can take with that and go, they improperly set this up.
Wait. But to filter water of what? I mean,
That's
sorry, compare reverse. I mean, I'm going to give a silly example, but just to,
Sure.
I mean, right? You might have a filter when you buy a particular, I don't know, faucet, right? Like a Moen faucet comes with its own filter, which is different than a reverse osmosis, right? For what it filters out, which is different than what your refrigerator may have in a filter, right? What's the intended purpose in filtering out? So the fact that filters could exist and could filter out certain things, how does it tie to the issue here with regards to the hydrazine?
Well, it goes back to what plaintiff's attorney was talking about when he discusses the article, that he could not exactly indicate the amount of hydrazine, but that if it was set up properly, it would reduce hydrazine.
Can you point me to where in his report he says if it was set up appropriately, it would reduce hydrazine? Please?
Well, again, Your Honor, I'm going, I'll find it, I apologize.
No worries. I didn't see that he went that far. That's the reason why
Well,
I'm trying to have an understanding.
And maybe I'm
If it's there, no worries. Point it out.
so in the opposition, they identify that this is a causation testimony, correct? And so and so as far as that goes, again, identifying the couldn't indicate the amount of hydrazine left, but he does indicate that it is used to, or that it would reduce, but he couldn't speculate. He didn't want to speculate into regard of how much it would reduce if it had been set up properly.
Appendices. Yeah, no worries. I'm in plaintiff's appendices.
So in Exhibit U from October 30th, 2023, Dr. Alex Rebstruck's deposition at 81.5 through 18.
Okay, hold on a second. Are we talking APP between 94 and 106 to plaintiff's motion? Or are you referencing me to something else, please?
It's in our opposition when we're identifying Alex or Dr. Alex Rebstruck's deposition testimony, where he states that when referring to the ozone and the process used, that there would be a destruction of hydrazine. Now, whether or not he could opine as to the amount, he did not. That's where it would be left to the medical experts to determine causation. And then in Exhibit J, he further addresses experiments that the complete hydrazine removal from water solution has been achieved. And so again, he's referencing the article as previously discussed. He did not take it a step further in saying by how much, just that when used properly, hydrazine can be reduced. And that opinion, we believe, is not a causation opinion. That's an expert opinion. And medical experts then can opine whether or not hydrazine caused Mr. Hunwardsen's injuries. And then
Feel free to continue. I'm just double checking something. He's
So
definitely.
then again, he cites in the Golta, again relying on Golta, according to the study relied on by Dr. Repchuk, ozone treatment has been referred to as the most effective and ecologically friendly method for the treatment of hydrazine-containing wastewater. So he's basically saying that if the ozone machine, agreeing with Golta, that if it's set up properly, it will have an effect on hydrazine. Now, he doesn't want to go the next step further as to how much or if it caused or does not cause. So his knowledge regarding the ozone machine and system, which he is an expert, which he can testify to, should be permitted. Whether or not it caused, that is not his area of expertise. Thank you.
I appreciate it. Thanks very much. Counsel, you get final word.
Judge, first of all, they brought up two witnesses that they say support this motion. I don't see how either one of them has anything to do with it, but I'll address it briefly. Dr. Hudson, they said, he testified that there's not hydrazine in every retail bottle or some such nonsense. Dr. Hudson is the hepatologist in this case. Dr. Najam is the hydrazine expert, probably the world's foremost expert on hydrazine. Dr. Najam explained in detail how there's hydrazine in the concentrate, and if the concentrate is used, it's in each and every bottle. Maybe not as much in each and every bottle, but it's in each and every bottle. So they keep talking about Dr. Hudson when he's not the appropriate witness. Now they run to Casey Akins and say, he testified the concentrate was made differently. That is not what he testified. Casey Akins did not make concentrate. Concentrate was only made by Blaine Jones in the concentrate room. Okay, what Casey Akins testified to is on this one occasion he added more concentrate for reasons we'll get into later. But he did not say anything about some of the concentrate has hydrazine and some doesn't. So they're trying to point to these two witnesses to support the proposition that there's a differential in hydrazine concentration in the bottles. That is the linkage that's missing. They say, Dr. Repchuk's going to say that ozonation affects contaminants. True, but they don't say what type of contaminants. The contaminants that ozonization is intended to treat are the two bacteria I mentioned. It is not intended to treat hydrazine, okay, because there's not supposed to be hydrazine in water. And that's why when you ask counsel, where's the study, he ran to wastewater. Water after it goes through the sewage system that they collect out there in Pittman somewhere and they treat. There's no treatment for hydrazine in any commercial water plant that I know of. And so what they're trying to say is that if there had been proper ozonization, it may have had an incidental effect on the hydrazine, not intended because that's not the purpose of ozonization. It may have had an incidental effect, and Dr. Repchuk can't give you the linkage. And this is the real important part, Your Honor. They say, that's for the medical experts to talk about. Well, none of the medical experts on either side knows anything about ozonization. None of them has mentioned ozonization in their expert reports. There's been no questions or answers in any of the depositions about ozonization. So for them to suggest that they're going to call an expert, or we have an expert that's going to come in and say, I think Dr. Hudson's or Dr. Repchuk's theory on ozonization is right. And because of that, the ozonization would have done this, that much, the other on the hydrazine level, and that would have made a difference in this case. That would be linkage, Your Honor, but that is not here. That is what they're trying to have the jury do in their own minds without any evidence, without any expert testimony. They're just trying to throw this out there and just have some jury nullification going on. The jury thinks, blah, blah. But that's why you need expert testimony to tie it all up. And since they've already admitted that Repchuk didn't do it, and they haven't told you any medical expert that's going to do it, and if there is one, tell me who it is and show me the report. Because I took all the medical experts myself, Your Honor. That is not discussed in any of their reports. So I think this brings us back to the point that I was harping on originally, which is where is the linkage? He can't say whether this ozonization, assuming for the sake of argument that the ozone machine wasn't hooked up, that's a debatable point too, because he got there a year later and took a picture. So I don't know if they can put a foundation together for that, but assuming they can, where is the linkage that would have changed the amount of hydrazine by 1%, 1.2%, 2%? There's no testimony of that. And so instead, they want speculation that it would have been a significant difference. And so for those reasons, Your Honor, this testimony, and again, like I've already said, we're not trying to preclude all of Dr. Revchek. He does say some other things that we haven't challenged. But this ozonization opinion should be out. Thank you, Your Honor.
Okay, and the court agrees. Realistically, attached to the motion is the deposition testimony. Starts around page 66. It was APP 102. Counsel walks through the question and whether or not he can actually set forth, because it even says, so without setting up this test, we can't tell whether the hydrazine destruction under the conditions in real water in Henderson would have been 1%, 5%, 10%, 50%, over 15 minutes, 30 minutes, 40 minutes. We just don't know at this point. There's an objection. Objection is to form and foundation. The witness says quantifying it, no. Based on my report, I cite the ecological profile for hydrazine for oxygen is a dominant mechanism for hydrazine decomposition. The FDA has established and recognized ozone treatment as a good manufacturing practice for bottled water industry, and given the concentrations of hydrazine that are lower than the concentrates in the test conditions used by Dr. Galata and colleagues, it would be a destruction of hydrazine, the rate at which it happens, and the resulting concentration that would need to be determined on running tests with the right equipment. Okay, Mr. Kemp then says, okay, so your opinion is that you'll have some destruction, but the rate you do not have opinion on that is right. The answer is you would have destruction, but I cannot comment on the rate. And question, okay, and I would also be correct that the Henderson Ampac skid, it would be the Venturi meter injection point. That would also have some sort of bubbler, correct? Sorry, that goes, that's a different, sorry, it was the page, ending up on page 81. So realistically, the witness has set forth in his deposition, he can't provide an opinion under Hallmark as to the issue, so the court has to grant plaintiff's motion eliminating number 24 to preclude him from offering opinion that the purported lack of ozonization at the Henderson plant would degrade hydrazine in water based upon his admission. He does not know the amount of degree degradation right out of his own deposition, so it needs to be granted. It is so ordered. And to the extent on any of these, I previously have not said it is so ordered at the end of my summary. Each one of them are it is so ordered. Okay. Moving on, document 651, plaintiff's motion eliminating number 29 to preclude defendants from soliciting expert opinions from lay witnesses, e.g. Brent or Blaine Jones, about whether outbreak was limited to the Henderson plant or extended to other locations, and or to preclude testimony about purported statements by FDA employees. This one I'm going to need to hear a little bit about because some of this may or may not be expert testimony, so I need a clarification of the actual testimony that sought to be precluded by the two Joneses, as well as the aspect of the FDA individuals and the hearsay exception set forth in the opposition. The opposition, 817, was Real Water's opposition, and 840 is ETT's opposition, and the reply is 916, and I mentioned the underlying document. The motion is 651. Go ahead, counsel.
Your Honor, we had the benefit of going through this trial in Gallagher and learning how plaintiffs, in response to plaintiff's position, how defendants, Real Water, wanted to get in expert opinions through lay witnesses, and we thought this, as a result, we thought this motion was appropriate and should be beneficial to the court. Brent Jones is the vice president, executive vice president of Real Water. He was the president, he was the owner, he's the father of Blaine Jones. And Mr. Brent Jones, as well as Mr. Blaine Jones, was asked questions by Real Water's counsel in an attempt to get what I would consider to be epidemiological opinions as to what caused this outbreak. Now, they're not epidemiologists, they're not scientists, Your Honor. We learned through discovery. They're not any form of expert, and yet they were asked expert-related questions. For example, Brent Jones gave testimony or comments that the outbreak was caused by home delivery only. And certainly, Brent Jones didn't know what caused the outbreak. It wasn't until the FDA found hydrazine in the concentrate that we became aware of what caused the outbreak.
Sure. Can I stop for one quick second?
Sure.
What I was trying to get from my clarification question, right, is presumably, and once again, you all, how you're doing this case, and you did a different case, stay tuned, right?
Sure.
But are you seeking to preclude if there is an examination of kind of how they became aware of the outbreak, where the outbreak occurred. I mean, that's lay testimony. So that's why I'm trying to get the distinction between what you're
No
calling
worries.
expert versus lay, if you don't mind. please.
Sure, Your Honor. We're seeking to prevent them from giving what I would consider to be scientific opinions,
Okay. Example.
Not-
Yeah.
not a chronology of what happened.
Okay.
That's different. Certainly their perceptions are allowed as lay witnesses. We understand that under the rules, and we understand that under the statute. So that's not what we're trying to prevent. We're trying to prevent these glossary, kind of conclusory statements where they say, based upon our involvement with the FDA, this is only related, hydrazine was only created in the Henderson location. That's something that they would take from, that would be a scientific opinion, Your Honor, because someone would have to actually do an investigation to determine where the hydrazine was created, in what products hydrazine was contained. They didn't test themselves. So there's no way in the world Brent or Blaine or Casey Aiken or any of them should be able to come in and say, hydrazine in this amounts were discovered here and they were only here, because they never did the test themselves. The FDA did the test. Eurofins did the testing. Epidemiologists have investigated it. Southern Nevada Health District investigated it. They can testify that the FDA came in. They can testify that the CDC came in, that the Southern Nevada Health District came in, and that they were part and parcel of the investigation. Those things they can testify to. And you're right, Your Honor. They should be allowed to give a chronology of the events and their roles in that investigation. But they can't give what I would consider to be expert opinions, because it's not allowed under Hallmark, it's not allowed under Marsicato or Williams. They're not engineers, they're not doctors, they're not epidemiologists. So that's the distinction, Your Honor, broad distinction of why we filed this motion. So I try to give you an example of what we believe they can do, but it's different than saying hydrazine was only in the home and office delivery and not in the retail bottles. How would they know? It's not something that they actually investigated themselves. They're not equipped or have the proper foundation to do so. It was never done. There's no evidence that they did it. So they shouldn't be allowed to talk about that.
So, but there's a specific example, right? Page 6 of the opposition of real water.
Yes.
I'll read it just so everyone's clear what the court's referencing. So page 6, line 15. Says, for example, when Brent Jones was asked by plaintiff about his awareness of reports that related the consumption of the 5-gallon delivery product, Brent Jones merely responded that he was aware of the report and its findings, and he did not believe there was any problem whatsoever with the ready-to-drink and its bracketed product and bracket. The footnote 8. Brent Jones did not assert, as plaintiffs alleged, that Brent Jones' opinions of the products related to the outbreak was based on a report he was being asked about. Further, then it goes into the Utah Department of Agriculture. Brent Jones said he had not seen the document, but if he asked to conform with his understanding of the problems, to which he replied in the affirmative. So those kind of highlights that slippery slope, gray area, whatever cliche people like to utilize. So how does the court make a well-reasoned determination of which of those versus dealing with this on a question-by-question basis with a reminder to everyone that, you know, everyone knows the evidentiary rules, what lay witnesses can do, what experts can do.
Right.
But how do
Well,
I'm seeing a challenge on this one.
and I do too, Your Honor. In terms of, you're reading from the bottom of page 6.
Right, so line 15, yeah.
That's right. In terms of the Utah Department of Agriculture and Food Consumer Advisory Board, that actual report came out before the FDA got the findings on the hydrazine revelation, number one. So he was responding to an article that had not yet actually found that the hydrazine was there. So this was a preliminary document, I would suggest, that Mr. Jones was responding to. I don't believe he can testify, and this is one of the issues that actually comes up on any other motions, Your Honor. You may have seen this as well.
It's a cross-reference on the other people's motion,
Exactly.
number 3 and 4, I think it is, but go ahead. Yeah.
We had the Utah press release, and then we had this document. In terms of the Utah press release, we don't know the author of that release. we don't know what investigation was done. We know it came before the FDA's finding of hydrazine, and no one took the deposition to authenticate that release or to figure out who the author was to get whatever information would support the press release. So to have Mr. Brett Jones talk about it is hearsay on top of hearsay. So that certainly he would be precluded from testifying on that document just under the hearsay rule. In terms of the Utah Department of Agriculture and Food Consumer Advisory, again, it would be hearsay because Mr. Jones can't simply speak to information from that board without having any support for it, because no one deposed anyone from the Utah Department of Agriculture and Food Consumer Advisory Board, and Brent Jones does not know the foundation behind that document. So it would be hearsay, it would not be admissible. So what I believe Real Water would want to do, or try to do, which would be improper, is to get him, Mr. Brent Jones, to get up and tout the results of that investigation from Utah Department of Agriculture and Food Consumer Advisory, and try to use that to support the position that it's only the Home Office delivering. That's what we're trying to prevent, that hearsay, and we're trying to prevent him from getting some kind of epidemiological opinion in without any support and without being an epidemiologist. Now, I don't, given the stipulation, and I do this so guardedly, mention stipulation, because I don't know if we have the copy or here, the printer here yet.
It's allowed to set up, so I haven't set it up yet. So
It's allowed to set up,
in the
okay.
interest of not disrupting
So at the
board.
next break, Your Honor, if we could set it up so we could print this thing out, and then I would not be as guarded about the use of that stipulation.
You would want a judge not to make rulings on a document that they haven't seen. I mean, come on. You
Your
know,
Honor,
as experienced
listen, I
litigators,
agree.
mean,
I
that comes as a
understand.
surprise to no one.
It does not.
Go ahead, please.
And so I say that because in our motion, Your Honor, we raised NRS 51.065 in terms of hearsay. And certainly the court recognizes that. In my opinion, Your Honor, we're trying to prevent this from happening again. And I'm not going to necessarily say it was Real Water. In that case, I believe there were attempts by the other defendants to get that type of, solicit that kind of testimony from employees and officers or representatives of Real Water. And we're trying to prevent that from happening now because it just confuses the jury. It's not, it is an admissible hearsay and there's no probative value to it. Hopefully that gives you some sort of line, Your Honor. Maybe it's not as bright as the court would like it, but we don't want statements from Brent Jones or Blaine Jones indicating that they know how this outbreak occurred and what caused it. Because if they knew what caused it while it was happening, they should have prevented hydrazine from being in the water in the first place.
We appreciate it. Counsel for Real Water, document 817, your opposition. Go ahead. It's already been quoted from.
Your Honor, Joul Odou on behalf of Real Water. Matthew Kaufmann's on blue jeans. The screen got turned off, but he heard the argument and he'll be presenting on behalf of Real Water.
Okay, right. Do you still have it on doc cam? Is that the reason why we're not getting? Yeah, let's switch it. Do you mind switching it over so we can? Just as your friendly heads up is, if the new audio-visual rules get fully approved,
Okay.
they require audio-visual. Okay, hold on a second. There was a second ago. There we go. You can can you minimize? So there we go. Go ahead, counsel.
All right, Your Honor. Thank you so much. I want to start, Matthew Kaufmann, on behalf of the Real Water defendants. I want to start by saying generally, I actually kind of agree with Mr. Parker's position here. And I also agree that, there's a limit to what lay witnesses can testify to. I just think that it should be applying to both everyone, and that's my initial point here is that I think that there should be a bright line, not just for Brent and Blaine Jones, but for all witnesses. And I'm sure that'll be the case going forward. But I also just kind of want to say generally, we are not planning on eliciting the type of testimony that Mr. Parker discussed from Mr. Jones, either of the Joneses. In fact, we didn't elicit that testimony during the course of the deposition. That was co-defendants counsel who did all that. So On a whole, I think plaintiffs' counsel and I are kind of in general agreement as to there are limits here. But I think plaintiffs' counsel is trying to, the way this motion is written, it's restricted to my clients as opposed to all witnesses generally, and I believe it should be applied more broadly. I also just want to state for the record, Real Water is not trying to make a distinction here between the HOD and the retail bottles. So I'm not real sure what Mr. Parker was talking about as to that. So, yeah, Your Honor, that's pretty. Let me just check my notes real fast. I apologize.
No worries.
Yeah, those are the points I wanted to make with you today, and with that, I'll rest.
Okay, counsel for ETT Terrible Herbst, go ahead, please.
Jan Tomasik for Terrible Herbst. Your Honor, taking a step back and away from this motion, we have to understand the context of why plaintiffs seek to preclude so-called expert opinions here. It's because of the fact that Myles Hunwardsen consumed HOD product at copious amounts at the same time that he alleges consumption of retail bottles purchased at Terrible Herbst. The evidence shows that the HOD product that he was consuming was consumed in much greater quantities than the retail product. Now, coming back to what this motion seeks to preclude is so-called expert opinions. But these are four individuals, as laid out in our opposition, that have lay witness testimony to proffer as to their personal observations and their intimate knowledge of the manufacturing process. The four people that we outline in our opposition is Brent Jones, who is the owner of Real Water. His son, Blaine Jones, was the vice president of Real Water. And Casey Akins, who was a lead water technician, as well as Anthony Brown. And Anthony was in charge of the home and office delivery product during his time at Real Water. Now, the testimony they all proffer is all consistent in the fact that there were significant issues with the HOD product. Hence, this is why plaintiffs bring their motion attempting to backdoor those opinions as expert opinions, but they are not. First of all, Brent Jones was deposed as Real Water's NRCP 30B6. So he's testifying on behalf of the company that their investigations led to HOD product being the issue. Now, that's also consistent with all of the governmental reports. So when you look at those things in a totality of circumstances, it lends credence to the fact that these are not just opinions. It's actually what took place. The HOD product was causing injuries. Now, going further to Blaine Jones. Blaine Jones is the vice president, and he testifies as to his own consumption of Real Water, which is undoubtedly layperson testimony and his symptoms. Sure, he cannot give a medical opinion, but he can still testify as to how he felt and what product he was drinking at the time he had to present to the hospital. Going further as to Anthony Brown. Like I said, he was in charge of the home and office delivery product during his time. And there's deposition testimony on page 8 of our motion. It says, as far as you're aware, was the root cause of the recall in March of 2021 the 5-gallon HOD product? I believe it was the 5-gallon HOD product delivery only, yes. So he does not parrot or attempt to introduce, hearsay testimony. Real Water did its own investigation, and the people who had personal observations of the manufacturing process should be allowed to testify to that extent. Same is true of Casey Akins. He's the lead testimony where he brings home HOD product and his dog drinks it, and he has to take his dog to the vet. And so, on that front, that's layperson testimony. So I think that plaintiff's motion should be denied. There's undoubtedly layperson testimony that's been proffered by all of these individuals. They have, percipient knowledge of the facts and circumstances surrounding the manufacturing process. With that, I'll submit.
I appreciate it. Thank you so very much. Counsel for plaintiff got last word, but I'm going to ask kind of a precipitating question. Isn't the answer to the court's ruling to this one is everyone needs to comply with NRS 50, NRS 51, and the NRCP? Nothing broader, nothing more narrow?
I like that. I do like it. I like the fact that Mr. Kaufmann agreed with our position. And I thought I said before I surrendered or ceded the podium that it wasn't Real Waters Counsel that tried to, who asked those questions. It was the other defense attorneys in the case. Your Honor, to address some of the things that are, I think, really easy, we're not trying to prevent Mr. Blaine Jones from saying that he got sick or his dog got sick, that he was drinking real water. That's not the purpose behind this motion. The problem with Terrible's position is that they have no expert to link any of this up, any of the opinions they're trying to get out of these lay witnesses, and that's why they're doing it. If we want to take a step back, let's take a step back and look at the reason behind the opposition. If you don't have the appropriate experts, if you don't have the evidence, if you don't have facts that experts have used to put together a full investigation or provide solid opinions supported by Hallmark, then what do? You try to find a way to throw enough against the wall through lay witnesses who have that lack the required foundation, education or experience-wise, to give opinions on what caused this problem. And that's what they're trying to do, Your Honor. And we're trying to prevent lay witnesses from giving expert opinions consistent with the rule. And that's correct, Your Honor. When you look at NRS 50.265, lay witnesses can talk about what's rationally based on the perception of the witness and helpful to clear understanding of the text, testimony of the witness or the determination of a fact and issue. That's the reason behind lay testimony. Expert testimony, on the other hand, Your Honor, as the rule requires and as the case law requires, you have to have the foundation, both either in experience, education, and there's no experts that they have that will come in and who can say that only the home delivery 5-gallon jugs had hydrazine. Not a single expert will say that. And yet that's what they're trying to get out of these lay witnesses. And it can't be allowed. And so, Your Honor, I think by granting the motion, you're doing exactly what you suggested, that they have to comply with the rule. So that's a long way of answering.
Okay, no worries. Okay, here's the court's ruling. With regards to plaintiff's motion eliminating number 29, it's going to be granted as to all witnesses or all parties must comply with inter alia, NRS 50, NRS 51, NRCP 16.1, because that's how you would be designating experts, etc., and comply with the rules. The court's not expanding it. The court's not narrowing. The court can't and doesn't. And if there's a question with regards to whether or not a inquiry is being made violative of those, I will have to address that right on a question by question at the time of trial. But please make sure everyone reads those rules and is fully familiar with them. Thank you so very much.
Thank you, Your Honor.
Okay, it is so ordered. So now we're moving